a.m. on Thursday, September 22nd, 2022. We are meeting virtually via Zoom to convene a public hearing on three bills. 24-934, the Condominium Warranty Claims Clarification Amendment Act of 2022, and Bill 24-239, the Homeowners Association Strengthening Support Act of 2021, and Bill 24-240, the Condominium Association Strengthening Support Amendment Act of 2021. This hearing is streaming live and it's being recorded on the committee's YouTube channel named HEA Committee. Bill 24-934, the Condominium Warranty Claims Clarification Amendment Act of 2022, was introduced by myself, along with co-introducers, council members Nadeau, Henderson, Lewis, George, McDuffie, Gray, Shea, and Chairman Mendelson on July 11, 2022. This legislation would amend the Condominium Act of 1976 to clarify the standards and procedures that govern the resolution of a claim filed upon a condominium developer's warranty against structural defects. The condominium warranty claims process has been a topic of council concern for many years and has received heightened attention due to the growing number of condominium developments and conversion projects. Although condominium developers are required to post a bond with the Department of Housing and Community Development in the amount of 10% of the construction or renovation costs, questions revolve around whether or not this amount is adequate and if the transaction is timely. Additionally, DHCD, the Department of Housing and Community Development, is viewed as lacking the resources and legislative guidance to responsibly administer the law. From June 17, 2020 through January 28, 2021, temporary measures PR 23-659 and B23-621 and B23-622 were in effect. Today's bill results from input by a working group of stakeholders that convened numerous times during the past year. And this bill provides a series of technical changes to ensure that condominium owners are reasonably protected against structural defects. And these changes include specify the timelines for claims and proceedings, clarifies the amount of the warranty security payment, and the definition of structural defect, and that developers must provide sworn affidavit attesting to the cost estimates that inform the bond amount, requiring the mayor to maintain a publicly available database online of the warranty security bonds, providing an opportunity for de novo appeal with the Office of Administrative Hearings, requiring that a warranty bond be posted when the condominium registration order is issued, and providing for a mayor's estimated fund providing financial assistance based upon the need to condominium owners facing warranty issues, inspection fees, attorney fees, etc., and providing for punishment of reckless or knowing violations of this law, and finally providing for the developer to provide copy of the bond to the condominium board, and that the board members' bylaws cannot restrict or hinder an association unit owner's rights to assert claims as needed. The second bill, Bill 24-239, the Homeowners Association's Strengthening Support Act of 2021 was introduced by Council members Trayon White and Brianne Nadeau on May 3rd, 2021. It would require homeowner association fees to be paid into an escrow account, and would also require that the homeowners association officers receive training on how to manage an association and remain in good standing with the District of Columbia. Additionally, it would require that the documents have a decision on the use of a reserve study. The third bill today is 24-0240, the Condominium Association Strengthening Support Amendment Act of 2021. It was introduced by Council members Trayon White and Nadeau on the 3rd of May, 2021. And this bill would amend the Condominium Act of 1976 to require the fees for condominium associations with more than 6 units are paid to an escrow account. It would also require that condominium association officers receive training on how to manage an association and remain in good standing with the district, and that each association document a decision on the use of a reserve study. I look forward to hearing from all of the public and government witnesses today regarding these important bills. I ask that each witness keep their remarks to 3 or less for individuals, and of course 5 or less for organizations. And this will allow all of our witnesses to be heard. All written testimony received by the committee will be a part of the record. So if you have not submitted your testimony, please email it to housing@dccouncil.gov, G-O-V. That again is housing@dccouncil, one word, .gov. At this time, I would like to recognize any of my colleagues. Do I have colleagues on that I maybe cannot see? Staff?
I don't see any colleagues, council member.
All righty, thank you so very much. All right, well, we will first begin by hearing from our public witnesses and then followed by our government witness a little later. And so we will begin. Let me get to my list. Okay, the first panel is the panel on the Condominium Warranty Claims Clarification Amendment Act of 2022, Bill 24-0934. And the panel that I have Sheila Lynn, Todd A. Simpkins, Paul Johnson, Ann Arnold, and Alexis Blanc. All right. It's getting a little feedback here on the phone and trying to figure that out. All right. We'll begin with Ms. Lynn, representing the DC Building Industry Association.
Thank you. Thank you, Chairperson Bonds and members of the Committee of Housing and Executive Administration and staff. My name is Sheila Lynn. I'm an attorney with the Law Office of Ballard Spahr, their DC office, and my practice focuses primarily on the representation or development of mixed use and condominiums and planned unit communities. And the vast majority of my time is spent on guiding clients through the warranty and construction dispute process. I've practiced in this industry for over 37 years and have been representing either associations or developers that entire time. I believe I've represented either the representation of associations or developers on probably hundreds of warranty and construction disputes over the course of my career. Today, I'm testifying on behalf of DCBIA, the DC Building Industry Association, which is the leading voice of the real estate development community in the District of Columbia. DCBIA appreciates the opportunity to present testimony for the record for Bill 24-0934, which is the Condominium Warranty Claims Clarification Amendment Act of 2022. We appreciate all the time and effort that has been put into drafting the bill, and certainly the consideration of comments from DCBIA on previous versions of this bill. However, while we generally support improving the current procedures and protecting the financial security of associations and individual owners who are faced with structural defects, we cannot support the current draft of this bill. It proposes an unfair and burdensome process to addressing claims that will discourage developers for investing in condominium projects in the district. This will no doubt have the result of reducing housing in the district for seniors, workforce, affordable homes, all of which are often provided through condominium projects. DCBIA has many concerns regarding the bill, and since we have limited time, we're focused on some of the bigger issues that adversely affect the community and the development of condos in the district. Before addressing the specific issues, I think it's important to briefly describe the process that's often followed by most associations. Most condominium associations engage an engineering consultant prior to the expiration of their 2-year warranty period. The initial report is often based on visual observations. Testing and research is often needed after receipt of that report in order to either understand or determine a resolution, if needed, of the concerns. In order to preserve the claims, the association will often and most typically notify DHCD so that any bond funds or warranty security remains in place as they resolve the claim with the developer. And then the majority of these claims are resolved amicably. I won't say every one of them, but a very large percentage of them are resolved through joint investigation by the parties and involvement of both parties in determining a solution. And often through dispute processes that are dictated by the governing documents. The proposed legislation seems very focused on dealing with scenarios where the developer is either unresponsive or what we would probably consider a bad apple. However, this seems to punish all of the better developers or the ones that are doing what they're supposed to and working cooperatively with the association. So it inhibits that process. As drafted, the following are some major concerns with the legislation. First, the process for addressing warranty claims commences upon DHCD determining that a claim has been, quote, perfected. However, no objective standard is contained in the legislation as to what constitutes a perfected claim. Based on experience and based upon the lack of direction, there's virtually no standard. Almost anything that's submitted by an association is going to be considered perfected. Second, the bill allows for summary determination by DHCD on the release of bonds without reasonable due process offered to the developers. In such case, there's limited time to review, and as a result, developers are going to be forced to be in a position to file their claims or file their appeals to the Office of Administrative Hearings, before, they can be held responsible for, being, the amount being released. The bottom line is that this is going to present almost in every case a situation where there's going to be an administrative dispute. It's actually going to end up costing the parties more because there's not enough time nor reasonable process for the developers to work with the association to resolve the issues. A third significant concern about the bill as it is currently drafted is that the technical review that's needed for these claims, and in most cases they're fairly complex and they involve multiple or could involve multiple disciplines, there is not sufficient either funding or resources to DHCD to evaluate and consider the claims or consider the issues raised by either party. As a result, there's going to be more legal action because we can't resolve the issues. Finally, there is the potential for double jeopardy for the developer. There's nothing in the bill that provides for a release or any kind of resolution of claims so that the association or the homeowner or whoever the claimant is can file legal action on the same issue that they might already get bond funds on. So that's an issue that definitely needs some concern, some consideration. DCBIA has a number of other specific comments with respect to the bill, and there's too many for us to go over. I'm trying to focus on the things that we think are most important and most concerning to developers that need sort of attention before this bill can be considered fair to both parties. And we anticipate submitting written testimony in order to present our more detailed recommendations, and as well as working on potential edits or amendments to this bill to carry out a more fair approach to both parties. And I'm happy to answer any questions, but I think that summarizes our most primary issues.
Thank you very much. Our next witness, Mr. Sinkins.
Yes, thank you, Councilmember Bonds. Thank you to the staff. My name is Todd Sinkins. I'm submitting this written testimony to the committee in my capacity as co-chair of the Community Association Institute's Legislative Action Committee for the District of Columbia. CAI is a national organization that represents the interests of people living and working in condominiums, cooperatives, and homeowners associations throughout the United States. It has more than 60 chapters worldwide, with the largest chapter based here in Washington, D.C. CAI is supportive of this bill and its objectives. The bill represents a compromise solution to longstanding problems with the submission, administration, and adjudication of cases involving defects in the construction of condominiums within the District of Columbia. When the warranty provisions of the Condominium Act were last amended a quarter of a century ago, the law included an obligation for either the mayor or council to adopt regulations administering claims alleging construction defects in the components of the condominium. However, neither the mayor nor the council ever adopted those regulations. This caused condominiums, their representatives, and condominium developers to operate in a regulatory vacuum that caused substantial ambiguity as to how claims made against the security held by the District of Columbia were to be brought to the applicable agency, which now is the Department of Housing and Community Development, and how determinations are to be made as to whether a structural defect exists in the award of funds from the security administered by DCHCD. This bill addresses those concerns. Substantively, it makes clear that violations of the building code constitute breach of warranty under the Condominium Act. Up until now, it was not uncommon for a condominium developer to argue that building code violations are not necessarily included within the scope of the defect, and often they will refuse to address such building code violations, thus leaving resolution of these issues to the condominium at its expense. Also, the bill makes a condominium developer responsible for correcting damage to units arising from a defect in the condominium common elements. Under current law, it's not unusual for a condominium developer to disclaim responsibility for such damage. With respect to the warranty security itself, this bill creates greater definition and clarity as to how the amount of this security is to be determined, requires it to equate to action costs, both at the time of initiation of construction and updated at the end of any cost increases. This allows the warranty security to more accurately reflect an amount equal to 10% of the construction cost. The current law does not require any proof be submitted as to construction costs and relies solely upon the developer's own estimates. In my experience, without this change, it has not been unusual for warranty security to be estimated amounts at 3 to 5% of construction costs, not the 10% required by law. Procedurally speaking, this bill creates the first statutorily defined process for submitting, administering, and adjudicating claims against the warranty security. It creates a process that allows for the submission of a claim to the developer without the need to almost simultaneously submit a claim to DCHCD. Because it is not unusual for a condominium board to transition to unit only control only a few months before the 2-year warranty expires, it is very helpful to have a time period when the developer and condominium can attempt to resolve construction defect disputes amicably without having to involve DCHCD. The bill also creates clear timelines of the submission of claims, responses from developers, and action by DCHCD that allows all actors to have confidence in the process. Bill also includes a defined appellate process for decisions of DCCD to the Office of Administrative Defense. Another important element of the bill is a provision that allows for an award of reasonable attorney's fees and costs to the prevailing parties. This is important because condominiums during their initial years following construction often do not have sufficient money to pay for attorneys. Allowing for an award of attorney's fees shall help those condominiums that have limited finances to engage competent experts to identify construction defects and representation to help obtain the funds necessary to correct construction defects. The bill also includes clearly defined penalties for individuals that violate the provisions of the Condominium Act relating to the posting of warranty security and continuing to maintain such security. In my experience, historically, DCHCD has been unable to act effectively against developers that fail to post security, post inadequate security, or post fraudulent security due to a lack of effective legislative tools to address such issues. In summary, this bill is long overdue. The current law simply has too many flaws that act to defeat the purpose of providing owners of units in new condominiums with sufficient consumer protection to both ensure that the building is in a safe condition when built and that new owners will not face additional unbudgeted expenses arising out of conditions from the construction of the condominium. If this bill is passed, it will resolve a number of these flaws in the existing laws that have allowed certain developers to avoid responsibility for constructing a condominium that is structurally sound through the submission of inaccurate or fraudulent letters of credit or other forms of security. CEI believes that this bill creates a system where developers are required to provide security in the form and amount sufficient to back up their warranty obligations, and that create a logical claims process that will provide greater clarity to all parties and eliminate certain procedural impediments currently imposed by DCCD in the absence of clear statutory direction. This bill will greatly reduce the use of the court system to adjudicate these issues, saving homeowners millions of dollars. Furthermore, this bill results in greater opportunity for the condominium homeowners and the developer to work together in a reasonable timeframe to negotiate a reasonable course of action for warranty protection. This, in turn, will reduce the likelihood of a catastrophic incident, such as what happened at Champlain Towers South in Surfside, Florida, by creating a warranty bond enforcement process that has meaningful consequences to those parties who violate their warranty obligations. Thank you for giving me the time and opportunity to provide testimony on this important topic. And thank you for your service to the residents of the District of Columbia. CEI supports the bill as submitted.
Thank you very much, Mr. Simpkins. Mr. Johnson, Paul Johnson, representing ANC 4C.
Yes, thank you.
Mm-hmm.
Can you hear me? Okay.
Yes, yes.
Great. Thank you so much for the opportunity. I think this is a very important bill that affects my constituents. I am a ANC commissioner in 4C in Ward 4. I am speaking, however, in my own capacity. I'm not representing ANC 4C, but I have constituents who are condominium owners who have had some really horrific, arduous experiences in trying to seek redress for structural problems with their homes, as well as with the quality of construction on their homes, and have been through many procedural hurdles with respect to their bonds held in escrow, problems with respect to oversight from DCRA, and also an uneven power relationship with the developer and the builder. And my single member district encompasses Georgia Avenue. So there's several examples of buildings and dwellings along the Georgia Avenue spine and corridor, as well as some of the adjoining streets in Grant Circle. And I've heard similar tales of these problems of trying to redress their issue. So I flag that for the committee, that it's a problem here, that some feedback that I've heard is that perhaps there needs to be a more expansive definition of just structural problems. Sometimes it's just quality of construction. And I just want to flag that for you, that it's a problem here in Ward 4, in Petworth, and in Grand Circle. I appreciate the time of the committee. I will provide written comments, and I'm here to answer any questions that you may have. Thank you.
Thank you very much, Mr. Johnson. Now we'll turn to Ms. Arnold, a public witness. Ms. Arnold, are you still with us?
Yes, I'm here.
All right, okay.
Morning.
Please.
Yes, I'll just, I compiled a list of grievances that the people in my building and I experienced after we purchased a renovated building. And so this is the list of grievances that we have about the developer and the property manager. Most importantly, just an overview about what I'm going to tell you. There is no system of checks and balances in place. There were no consequences for unethical behavior by both parties. And then perhaps worst of all is the continued problems due to the developers and the property management negligence. By that specifically, I mean structural problems such as sound, lack of sound. I'm blinking. We have issues with sound in the building. So first of all, I'm just going to go through a list of about 5 points. The developer sold and actually gave the right to sell an unauthorized sale of public space inside the building to a private resident in order to close the sale of 1 unit before the association was formed. Point 2, failure to ensure high quality building materials, which resulted in structural defects such as sound insulation and water leakage around windows and internal pipes. Point 3, lost blueprints, later recovered in storage area by newly appointed building manager and me, one of the board members at the time. Point 4, finances. No record of building tax code information or correspondence with the city could be provided to us, the association. Point 4B, failure to provide a budget for the Petworth Flats Condominium Association as required by the bylaws of the association. Subpoint C, failure to maintain separate non-commingled operating and reserve accounts as required by the local jurisdiction. Subpoint D, failure to manage and carry out the fiduciary responsibilities and duties required as the agent for the association. Subpoint E, failure to execute and secure building insurance, which had another set of problems, which I won't get into. Subpoint F, failure to investigate and cancel 2 Verizon Phantom phone lines, resulting in needless cost expense to the residents. Subpoint G, has charged multiple residents for condo fees plus late fees after contract had expired. Subpoint H, failure to return funds from previous point to residents. And subpoint I, failure to return all money owed to the residents that after the building management was turned over. Okay, I have 20 seconds. Point 5, contracts. They did not execute 3 contracts, including the janitorial service contract, the landscaping service contract, and the exterminator service contract. Finally, I just wanted to add that communication, almost complete lack of responsiveness to the board members and countless residents on almost every request. Emails are available to demonstrate to what degree, and Mr. Johnson has those, has all the correspondence. Thank you.
All right, thank you very much. And we will get your testimony in writing, is that correct?
Yes, sorry.
All right, okay.
To Paul.
All right, thank you. Tosha, I want to mention that the sound is a little muffled for each speaker. It's not coming through clear. I don't know if there's some adjustment that you need to make on our part here, but
everyone should mute except for the person speaking.
Yeah, I think everyone is muted, but what's happening, the sound is very muffled, what I'm getting. Okay, all right. Our next witness is Ms. Blanc, another public witness. Ms. Blanc, are you still with us?
I am, council member.
All righty. Please go ahead and welcome.
So I'm just a homeowner. No, in DC, I don't belong to any other associations. So thank you for the opportunity to relay my testimony, and I just start by saying as emphatically as possible, at a minimum, passing Bill 24-0934 is absolutely essential. And if anything, I would argue that the bill doesn't go far enough. But I'm certainly not one to let perfection be the enemy of the good. So I certainly want to lend my full support to passing it and adding these protections for consumers. I imagine, and so I drafted these remarks and I'm reading them, and I said, I imagine there's once again a long list of individuals on the schedule who will no doubt tell you that the provisions in this bill will create onerous, expensive requirements. And in fact, we heard just that from Ms. Lynn. And they'll no doubt cite the huge demand for housing in DC, and they'll no doubt threaten to build less housing if the bill is passed. And my response to those individuals and Ms. Sheila would be unequivocally, thank goodness. You would be doing all of us a favor. I'm currently staring down near bankruptcy because of the generosity of developers and the rules that currently govern them. Buying a home was my dream, and now it's firmly my nightmare, and it keeps me regularly up at night. And it's all because I had none of the protections being discussed in this bill. So thank you, council member, for working on behalf of your constituents that really need this. So I'll give you just two examples of the issues that our building's been dealing with, and we have been dealing with for the past 6 years, trying to get the developer to simply do the right thing. So there's free flowing water that's running through the ceilings and windows whenever it rains, and even in heavy snowstorms. And there's water flowing from electrical sockets, one of which is at floor level, and it's easily reachable by the owner's 1-year-old little girl. And they actually had to move out of their home. And this is stunningly just the tip of the iceberg in terms of the structural issues and code violations. And these issues should never have happened. They're egregious. And yet the association is having to take the developer on entirely on their own. And to date, we've taken on around $400,000 of debt trying to pay the legal and engineering fees. And that was just to try to get the developer to do the right thing in the absence of a lawsuit. We were finally forced to file a lawsuit in May of 2020. And I believe in part, the developer forced our hand because they did not believe that we would actually be able to afford the legal and engineering fees that would be required to hold them accountable. And it has, in fact, been an enormous burden that's placed a tremendous amount of financial strain on multiple owners, and it's unconscionable. These past 2 years have made the parable, the past 6 years have made the parable of David and Goliath look like a fair fight, and consumers desperately need the protections proposed in this bill. We've encountered challenges with the condo warranty laws as implemented and enforced, including the bond was not even posted at the time of the sale. Not only did the developer not post the bond, but there are indications that suggest the estimate of construction costs was underestimated. For example, the sum total of the bond for our building was $67,000 roughly. Does that seem credible to committee members that a building originally constructed in 1911 could be remodeled to create a 30,000 square foot building with 13 units for only $670,000? There absolutely needs to be an entity holding developers accountable to make sure the developer has not lowballed the construction costs, let alone ensuring the developer actually places those funds in an escrow account. And the developer has been telling us with a straight face that the significant damage to the building and units were not structural defects and the code violations were not structural issues. They denied were not structural defects rather. And yet, when we tried to work with our building insurance to address these issues, they denied our claims because the damages were, you guessed it, related to and caused by structural defects, which are explicitly included by the insurer. So obviously these two positions cannot coexist and be true. And the legal fees incurred seeking the bond and remedy have been staggering. The developer made us pay all of the engineering costs that ran in excess of $80,000 to prove that there were structural defects and code violations, even though at that point in time, one unit had a waterfall flowing from his ceiling in his hallway. And even though the developer's own engineering consultant had previously completed tests and reported the absence of a properly installed water-resistant barrier throughout the building. And we know that because they accidentally sent us their own engineer's report. Now, the entire financial burden has rested on us with the provisions in the current statute. So it's absolutely essential deterrent that developers be required to pay reasonable attorney's fees. So again, I'll just wrap up. This bill is an essential first start in the fight to protect consumers. There categorically needs to be a body making sure the developer has not misestimated and lowballed construction costs and has actually posted the bond. And again, the entire financial burden has been placed on us to try to hold the developer accountable. And it's absolutely essential deterrent in order to protect future homeowners that they be required to pay reasonable attorney's fees. I know DC needs more housing. Everywhere in the United States needs more housing. I'm absolutely certain, though, that no one needs this kind of housing. I would categorically be better off if this condo would have never been available for me to buy. If homes ripe with structural defects is a cost that hopeful home buyers must accept in order to solve the housing crisis, then I don't know what to do. That is just a terrible situation. And it's my hope that future legislation will go further. Developers should also be required to obtain a $5 million insurance policy that's tailored to cover structural defects, not a general liability project policy, but specifically construction and defect policy. So I'll stop there. Thank you for your time. Please, please get this done for the sake of all unwitting, hopeful home buyers to come behind me. They need you and they need the protections in this bill. Thank you, Council Member.
Thank you very much for your testimony. Before we move to the next panel, which is primarily concerned with, I believe they are, is this the same bill? Yes, the same bill. Okay. All right, I will ask a few questions for all of the witnesses. In September of 2020, the committee held a hearing on two proposed bills to amend the condominium warranty claims process. Could you explain the main differences you find in what we're presenting today as what we had before us in the past? I know, Mr. Simpkins, you've been a part of the the working group that was concerned with these issues, and a representative from your organization. And I believe also, Ms. Lynn, that there's been a representative from your organization that's also. So if you two at least could give us some sense of what the differences are, I think that would help the public.
I'm happy to jump in. I think one of the important things that's sort of missing in this that I know was part of earlier discussions, and I can't recall specifically if it was addressed sufficiently in the prior legislation proposed, but the issue of determining what constitutes a perfected claim is still a big issue from our perspective. There is no direction here. There's no understanding as to what would be considered sufficient. And additionally, there have been discussions, and I believe DHCD has had some application of what would be constituting a perfected claim, but that seems to be missing now from the legislation. And I think that that's probably the biggest issue. The other is just the timing, the 30 days response and the automatic handling. I think some of those issues have not changed from the prior proposal. There may be some differences in the time frame. But again, those, in my opinion, and, based on my experience, and, I know I've done a lot of cases with Todd as well, Mr. Simpkins, there's just 30 days when we get, objective or, initial reports that primarily just point out concerns. They don't point out specific demands or specific fixes or specific repairs. There isn't really ability in a building of complexity that there's going to be a resolution in 30 days to understand how to fix it. There may be urgent issues, and I have absolute empathy for the owners that are experiencing serious problems with their building. I don't think that there's anything in our proposed course of action here that would not want to give resolution to those types of issues. But there's got to be a better system and a better way to accomplish it so that there's some balance here to both parties. And I recognize that homeowners are in a more reduced financial capacity to be able to pursue it, but there's got to be at least some other mechanism because there's just nothing in the DHCD capabilities and their current type of staffing and resources that can evaluate some of these buildings and make adequate decisions on how to release funds. So I think that those are sort of some of the issues. But I keep coming back to this issue of, number one, the timing of when a bond is posted is also a big distinction. The goal on this legislation, I believe, is posting the bond earlier in the process and actually at the time of registration of the condominium, which half the time ground isn't even broken yet. So it's very, very ahead of the timing. I recognize that you're trying to come up with a hook as to making sure that that bond gets posted, which I think is an important factor. That's just not a reasonable one, because that means a bond could potentially be posted 2 years before they even, sell the first unit. So there's those types of issues that I understand that there's ideas being used to try to create a better process and a better sort of protection and, make it easier for DHCD to assure that things get done. But I don't think the way it's being implemented is fair or reasonable to both sides of the table here.
All right. And so then, Ms. Lynn, I have to ask you, you brought up three very, cogent points. When we talk about the 30 days response time and you say it's too short for resolution, what is your thinking? What is your organization's thinking about this timeline?
Okay, I think for me, and this is based on my own experience, both representing associations and developers over the years, the importance is more on the timing is dependent upon the detail that's given in the claim. So if the claim comes around and says, I've identified these 20 things in the building that I think need to be looked at, obviously 30 days isn't going to be enough to look at them, understand them. Maybe there needs to be testing. Maybe there needs to be destructive review, or maybe there needs to be research, with experts in order to respond. If the claim comes in and says, here's all of the evidence and it provides greater detail, then, there may be a shorter time frame for responding. So it's a little difficult to say in every case that it's going to be, a set time frame, but I think at a minimum, we would need at least 60 or 90 days to have sufficient evaluation, consideration. Obviously, I understand if there's urgent issues, if there's a safety hazard, if there's, water pouring in and damaging property. I mean, those all create, more urgent situations that, some at least temporary measure needs to happen. But it's really hard to legislate all of that. I mean, I'm trying to come up with something practical. And I think most of my clients, that I work with, they want to fix, they want to resolve, they want to know what the issue is. And most of the time, if there's an urgent issue, they're going to address it in the short term. But there's not, there's not a one size fits all necessarily. But again, I think it all stems from what's a claim? What's perfected? Did they provide enough information for us to evaluate if you're the developer?
I appreciate those comments. Having been involved in one particular situation where homes were sliding off the side of the hill, off of a foundation, you know, I'm very sensitive to this whole process, and sensitive because, you know, people can lose their lives through this process. And then what Ms. Blanc said about the water pouring in and even in the wall socket, are you thinking that that evaluation could be completed, as an example, in 90 days or 30 days or 60 days, or would it take 6 months?
So I think that there's two sets of issues. One is immediate reaction in order to address a situation that's causing damage or is creating continued, you know, escalation of damages or a risk to, you know, persons or property. And then there's a situation where an issue is raised and it might require investigation. For example, I have a number of properties that have, you know, complicated HVAC related issues, and those are not easily resolvable. So that's my concern about the sort of the one size. Maybe there should be two stages of response in terms of at least immediate reaction for those, you know, like within that 30-day period for anything that is creating either a safety risk or a, you know, a damage, escalating damage to person and property. But, you know, in terms of releasing bond funds and, you know, in this situation, I mean, there's no proof that's contained in the claimant's, you know, submission. So, you know, we have situations where, you know, we make a claim and, you know, if we don't have a resolution within 30 days and they may not be having, you know, water pouring in, they may not be having, you know, any kind of safety issue. They just want, you know, improvements or things that, you know, are, you know, standard. You know, there's always going to be something in a construction case that, you know, or construction of a project that needs to be corrected. You know, to release funds before there's, you know, a full determination of how it's going to be resolved is not reasonable. So, you know, especially when there isn't necessarily any level of proof that's required by the claimant. I mean, there has to be due process on both sides here. I mean, so I understand the concern about, you know, something that might be urgent, but that's not the norm. I would say the norm is more things that might take some time to resolve, and they might be legitimate, but they're not necessarily something that forces immediate reaction.
All right, Mr. Sinkins.
Yeah, well, thank you so much, Chairwoman Bonds. You know, I do certainly have some thoughts, and of course, they're not going to be the same as Ms. Lynn's. I think that some of those comments ignore the fact that the statute includes within it a mandatory adoption of regulations to flesh out a number of the issues that Ms. Lynn raised as a concern, particularly with respect to the perfection of the bond and proof related to, or perfection of the claim and the proof related to that. I also, you know, it's interesting to me to talk about timeframes and the lack of equity in terms of, or practicality of requiring some form of a response within 30 days. One, I would note that, you know, I believe DCHCD strongly desires a time frames that allow these cases to move along. But I also would note that the condominium associations have a very small amount of time once the board of directors is under the control of unit owners to actually develop and present their claim. You know, I have had cases recently, including one with Ms. Lynn, where the board was controlled by the owners only for a couple months, and I got retained to represent them only 10 days before the end of the 2-year warranty period. So, you know, substantial time pressure to develop everything related to the claim during that initial 2-year period. I think that a condominium developer has the expertise, the contractors readily available to them, the project managers readily available to them to, upon receipt of a claim, begin looking at the issues raised and to begin developing at least a preliminary response to claims submitted by an association. You know, and I think that, yes, I agree that the timelines are among the differences between this version of the bill and the bill introduced 2 years ago. But I'm not certain that, I certainly wouldn't support any argument that they're inequitable. I simply don't think that's true. I think these timeframes are designed to allow the consumers of condominium units within the District of Columbia to receive the protections that they're designed to receive within a reasonable time frame, so they're not just spending the hundreds of thousands of dollars that Ms. Blanc so eloquently discussed during her presentation. I also would note that, you know, the comments with respect to the timing of the submission of the warranty bond. I think that the fact that there's an initial submission and a final submission is important to think about and talk about. You know, and the reason for this, and the reason that the time frame is being proposed to be changed, is it has not been uncommon for developers to fail to post warranty bonds historically during, you know, by the time a unit is sold. I can't tell you how many times I've either learned of it in my own practice or been told of it by other practitioners or other individuals in the condominium industry. And so when the working group, which included representatives from Ms. Lynn's organization, spoke about these issues, there was a focus on, well, what's the right time to submit them? And there was discussions about various things, various possible timeframes. And the time frame that kept coming up is, why can't it be at the time of initial registration? I don't know how that's unreasonable. They're getting that's a point in time where a developer is being evaluated and approved to build a condominium project in the District of Columbia. And necessary and important component of that is posting the security to back up their warranty obligations under the statute. Because it has not been a part of that initial application process, it has allowed developers to submit them immediately before a unit sold, not at all, or after a unit sold historically. And that's increased the level of what I would say is fraud and or improper behavior by developers in failing to comply with their statutory obligations on these security for warranty obligations. So, you know, I think that I would argue that this bill strikes an appropriate balance. And I similarly would argue that to the extent that it deviates from the bill presented or introduced in September of 2020, it does so because it reflects the input and comments from all the stakeholders that have worked hard on this bill for a period of 2 years since the September 2020 submission.
Thank you very much. I just wanted to ask you, Mr. Sinkins, what is your understanding of how we define structural defect, and then going to Ms. Lynn's point about determining perfective claim that seems to be missing from the bill?
So I'll introduce the first question first and then the second question. So currently the law defines it in two ways. Either it reduces the health and safety of the building. I'm summarizing, but health and safety of the structure, or it reduces the usefulness of the defective component in whole or in part. You know, that's a summary. So, you know, both, it could be just a complete danger based upon the defect to either property or the safety of the residents, or a component of the building can't be used in the way it's supposed to be used because of the defect. What this bill does is it introduces a third category. It introduces a category of, well, it might not meet either of those two categories, but it's subject to a building code violation that needs to be cured in order for the association not to be fined. And though it's actually not uncommon for building code violations not fit squarely within one of the two existing, categories of defects. And so I think in that regard, it really fills in a really necessary gap that's existed for a long time. I'm dealing with one with a client of mine right now where it's a code violation and doesn't really fit into these necessary categories. And we're having a heck of a time trying to get it resolved. With respect to the perfected claim, I think that's one of the topics that was intended to be addressed with more specificity during the regulatory process. I mean, during the legislative drafting process for this bill, I think there was a recognition that you can't define the complete evidentiary requirements to substantiate the claim. Now, although what I would say that there's a definition of perfected claim in the bill. It's defined as a claim that contains all information and supporting proof required by this section or any other applicable law or regulation that structural defect exists. I would suggest to you that if we're talking about a process, instead of talking about a regulatory process such as this, we're talking about how do cases get resolved in court. There wouldn't be anything more than this. I mean, essentially, the question, first of all, is, does the structural defect make one of the now two, hopefully in the future, three definitions of a structural defect? And has the plaintiff submitted sufficient proof to prove by preponderance of the evidence that one of those three categories of structural defect exists? So, my view is that to a certain extent, the argument of the building industry on this issue is a red herring. Because it's really no different than they have to deal with in court if there's a case. It's really no different than existing procedures, in the sense that right now, in order to prove a claim, an association has to submit evidence with required supporting proof that a structural defect exists as defined by one of those two definitions in the Act. I don't think this changes it. And I don't think that this is some improperly ambiguous definition. It's, I think, frankly, because you're dealing with literally hundreds and hundreds of possible types of defects when you talk about various components. I'm not sure how you would define it with greater specificity than this. So I simply don't accept that argument.
All right. Well, I appreciate getting the definitions from both of you, and because it's important as we move forward with as much legislative results as possible, I'll say. And so I'm hoping to do that. So thank you very much. Is Ms. Blanc, or let's see, Ms. Arnold or Mr. Johnson, do you care to add anything to this discussion about the time frame for expected response to the claimant from the developer?
Councilwoman Bonds, thank you for that. I think that I think that the reality is that homeowners want this resolved as well. And so, and we've certainly tried to be as patient as possible with our developer to give them the opportunity to fix it. No one wants to take on the legal fees and the engineering fees, right? They want to work amicably towards a resolution. At least reasonable people do. And we had the egregious issues that I pointed out, and we still spent 3 years trying to work with the developer to resolve them. So I think the reality is even if this 30 days is in the legislation, that gives consumers a fallback protection. But I think in general, people are just going to try to work in good faith. So I think it's reasonable, and I certainly appreciate the points that Mr. Sinkins raised. I think that all makes a great amount of sense to me.
Thank you very much. Mr. Johnson?
No, I appreciate you asking to just reiterate that as a commissioner with constituents that have real effect on lives, I see this as a matter of equity and equitable development. I think it's very important to have protections for consumers and for residents and for condominium owners to have a fair process to address the issue. Thank you.
Okay, and do you have a concern about do you think that the warranty itself, the period for warranty, should be extended, beyond 2 years or to 5 years, or just curious about that?
I've heard feedback from constituents. The process is too long to be resolved. I've heard them say that perhaps there should be a neutral third party to interdict in some of the mediation. And I've heard that the time period is a problem.
Problem too short, too long?
Too long to resolve. Too long of a process to resolve. Too many hurdles with respect to initiating legal action, and process questions about the length that have material effects on their finances and their quality of life, if that answers the question.
Yes, thank you. Ms. Lynn?
Yeah, hi, thank you. I appreciate the additional time. I just wanted to address a couple of quick points. One, with respect to sort of deferring the determination of what's perfected claim to regulatory process. There's been attempts to make regulations on this implementation of this legislation for, I don't know, since the original bill was put in place, 20 years ago or whatever it's been. It's never occurred. So I don't see that as being a legitimate way of addressing what is required to be submitted. The second point on that is that DHCD does not have resources to evaluate a claim as to whether something is or is not a structural defect. And the other issue is that the process provides for a very quick turnaround in terms of releasing funds. And as a result, there's nothing to indicate what has to be presented to identify the value of the alleged claim. So if there's, we have a big building and we've got millions of dollars that are posted in warranty security, how is they going to determine what amount is going to be released if they're going to agree to release it in response to a claim within 30 days or so? So that seems to be completely lacking of due process. I guess the other issue is that I can't get past the fact that if we have those types of warranty funds that are posted, we're in a situation where if there is not an ability to have discussion and resolution amicably through DHCD or with the association, the developer is going to have no choice but to post, to file their appeal. And that's going to cost the association more money too. And it's not necessarily desirable for any party to have to go through that process. But they may be forced to do that because funds can get released without regard to adequate proof. So I think that that's a concern. I recognize that there's desire and need to improve the process that we have. And I don't disagree that having some regulatory approach towards resolving these claims against the warranty security makes sense, and is something that's been due for some time and has been under discussion on and off over the years. But to put in a process that proceeds the way this one does requires developers to post bonds, 2 years potentially before they even sell an individual unit. There's got to be something more appropriate. It costs money to post bonds for any period of time. Many people post bonds in the manner of putting up a letter of credit, which is cash that's tied up for 2 years before they even sell a unit. And then also it does away with the ability to use any kind of mortgage on unsold units as the security, because that's been taken out of the legislation completely from what it was originally. So there's just a lot of things in here that, obviously we can't live with the way it is. Will certainly create concerns. I'm certainly willing, and I know DC BIA is very willing to, to put forth some other suggestions to try to work with the things that are needed, but also more fair.
All right, well, thank you so much. Oh, I see Mr. Simpkins. You need to speak to that.
Well, I certainly would like to address a few of those comments. One, I don't think that the fact that DC HCD has issues with resources is a reason to not move forward with the legislation. Frankly, they haven't had the resources historically. I don't believe that this bill increases the administrative burden on DCHCD. In fact, I think as drafted, it reduces it. So I don't see how that's an argument to avoid passage of this bill. I also, I hear comments from Ms. Lynn with respect to it's unfair to have the cost of a bond imposed, 2 years prior to possible unit sale. I would note that the current process imposes upon the association the entirety of the expense associated with determining whether a structural defect exists and the presentment of a claim with respect to that. And that there has, that the building industry has historically opposed any efforts to take responsibility for those costs. My interpretation of these comments is that the building industry is opposed to anything that might cause them to have an increased possibility of liability for damage or for structural conditions that they've caused. And they're going to characterize their comments in terms of either fear, which we heard at the beginning, well, you're not going to sell condominiums in the district anymore, or in terms of a lack of due process because they may finally be held accountable for the construction issues that they've caused. And I understand that not all developers act improperly, but a shocking percentage do. And particularly those that tend to build condominiums in areas of the district where people have the least amount of resources that they can bring to bear, try to address these issues. I think that this bill will allow those less, less economically fortunate elements within the district to have a fair shake at trying to get resolution. I mean, right now they sometimes, facing a series of bad decisions that they have to choose from.
I have another question that, to the entire panel. The bill requires that the mayor establish a financial assistance fund to support condominium owners that need assistance, for example, with inspections, cost estimates, attorney fees, etc., related to the warranty claims process. How much money should be reasonably allocated to this fund? Do you have any thoughts on that? I'll
speak first. I mean, I don't know that there's a really specifically defined amount that would be appropriate or reasonable. I do think that the administration of that fund should be solely based upon need. And I think that the problem, unfortunately, Chairwoman, is that with that is the fact that the amount of money is dependent upon how severe the deficiencies are, and also dependent upon the wherewithal of the applicants for funds from that fund. I mean, honestly, I think it'd be difficult for any panelist to do anything more than guess as to the appropriate number. But I do think that the evaluation of the appropriate number should focus on two things. One, sort of expected need within reason, and also the sort of typical costs associated with it. I really focus mostly on the need. I'd look at what is a typical amount that a condominium should expect to have to spend for a fairly normal representation to determine the existing defects and try to negotiate a reasonable result.
Okay, thank you. Anyone else?
Yes,
Okay,
yes,
Ms. Lynn.
Council member, but I just think it's important also that that amount is really dictated by the type of building most of the time. I mean, some buildings might be very complex and very large, and there might be substantial expense involved in evaluating it. Some buildings could be as much as 4-unit row houses. So it's kind of hard to really have a one size fits all type of assistance that might be needed. So it's something that I think that probably should be considered. But I would agree with Mr. Sinkins that obviously need is most relevant here. So I don't know how to evaluate that. I don't do enough of that type of representation to be able to anticipate, anticipated costs.
Well, then I'd like to ask you both for sure, then do you feel that 10% of the building costs, construction costs, and the value of the project is reasonable for warranty bond?
I would be happy to address that. I think it's very arbitrary. I don't know that, I don't know an alternative. We have discussed internally with some of my colleagues on the developer side to indicate, maybe a per unit fee might be, or a per unit number for establishing a warranty bond might make sense. But the downside of that is, again, the same thing as it relates to building type. And some buildings have massive amounts of amenities and other expenses that are necessary for the condo association to evaluate through their warranty process, whereas other buildings might have none. And so it's a little difficult to say what's the best mechanism. We have talked about maybe some range on a per unit amount making more sense than the 10% of the construction costs. I think with this new legislation and the proposed approach that good faith efforts could be made, and then there could be some way that there's a liability because they didn't calculate it correctly or something happens, and there opens up all kinds of exposure for developers for making affirmative representations about the cost of construction. And certainly the cost of construction is all over the place and changes constantly, especially in the post-COVID era that we're in. Having something a little more definitive than having to come up with a percentage and exposing people to making misrepresentations or misstating something or exposing them to liability or even penalties, or suspensions and all kinds of things that are imposed in this legislation maybe having a set flat amount might be a fairer and similar, simpler approach to take. The 10% is always difficult to determine what we're taking 10% of exactly. So I don't disagree that that's, got some issues in and of itself.
All right, I appreciate that.
If I could address it, in my practice, the 10% has, in most cases, been an appropriate, if it were posted in an actually 10% amount, would be an appropriate amount. I note that this bill creates 2 time periods where it's calculated and it's recalculated at the end, which I think addresses a number of the comments that Ms. Lynn just made with respect to estimates, because the second calculation and revision to the bond or security would be based upon actuals. So that would remove a lot of the uncertainty that she expressed concern about. I actually would have more concerns about a unit count calculation than I do percentage of construction calculation. I think that units can vary widely in terms of size, number, the nature of construction. I think a percentage of the construction costs is more likely going to align with sort of an anticipated cost of repair. I think there's going to be at least less room for deviation. I accept the fact it's not a perfect means of calculation, but I don't think a calculation based on unit count would be any better. I think it would actually be worse. And in terms of 10%, I've had a couple cases where it becomes an issue is actually if there's a catastrophic structural issue. If there were an issue with load-bearing columns, 10% is not sufficient. If the entire building leaks because of a flaw in the building envelope, that might not be sufficient, particularly for a high rise. But I think that the act of legislating is dealing with the vast majority of what's to be expected. I think that there's going to be circumstances where 10% is not sufficient, but it's, I certainly would support an increase, but I don't think there's another sort of mechanism that's any more fair than this, I guess I would say.
All right. Well, Ms. Blanc. Yes, I see your hand.
Thank you. I wanted to address his point of, is there a mechanism that would help get at this issue of what if, and I really truly do hope that I'm an outlier. So what mechanism might help get at these outliers? And that's going back to my remarks where I said that if there could be a component of the legislation that required developers to obtain a $5 million insurance policy that's tailored to cover structural defects. They get a general liability policy, but that honestly excludes explicitly constructional defects. And so this is just, they need a construction defect policy, and that would, provide that final safety net of, well, what about these contexts where there are those catastrophic failures, and otherwise, I think that the general points make a lot of sense to me. Of it's probably typical that the 10% bond covers it, and you can figure out what that number is. Reasonable people can figure out what that number is. But if I may have 2 minutes, I wanted to emphasize you raised a point about having a pot of funds for individuals that are trying to pay these enormous fees, and I just wanted to relay our experience. There's a woman in our building that's it's exactly those individuals that can least afford it that are the most victimized by the current system. She's in the inclusionary unit, and the developer made the inclusionary unit the largest unit so that it wasn't broken into two. They could get that tax write-off. Okay, I'm not going to say why they did it, but hers is the largest unit, which means by definition in a condo association, and we can't change it. We tried to waive her condo fees. We have to assess the largest proportion of that overall assessment to her unit because it's based on square footage. So she is the least able to pay for it, and yet she is the one that's really suffered the most burden, and we have no way of trying to take that off of her shoulders. And so if there was this pot of money, and yes, it does sound really difficult to figure out what it should be exactly, but I certainly would advocate for its existence. Thank you.
Thank you.
Chairperson Bonds, can I
yes.
just address this issue of, because I want to be cautious about the committee looking into this other issue of requiring construction defect insurance, because it really doesn't exist. There's not much out there in the marketplace. So I would be very concerned about adopting legislation that requires obtaining certain insurance that is not available in the marketplace. So I just point that out. I'm not an insurance expert, and I definitely, I know that many of my clients would be very happy if they could have obtained construction defect insurance, but it was not something that was feasible or available. So I just want to be cautious about that. And I do think that the issues about the inclusionary units and assessments and their percentage interest might be something for a different type of bill, but is definitely got its own issues, and certainly is a problem that needs for serious consideration, because I do recognize that is a concern, but not something that I think can be addressed in this scenario.
Well, thank you very much. And thanks to the entire panel. Sounds like we could go on for a few more days. And maybe replan whatever the legislation is. But I certainly appreciate getting your voices today, and thank you. Thank you so very much. And thank you, staff.
Thank you.
Thank you.
Thanks, everyone.
Thank you for the opportunity.
Thank you. We will now move to Bill 24-0239, Homeowner Association Strengthening Support Act of 2021. And our witness, we have one witness, public witness, Mr. Kerry Devasha. I hope I didn't butcher your name too much.
Well, if you did butcher it, I wouldn't tell you because you are the chairwoman.
Oh no, you can talk to me. I'm a regular like you.
Right. So I'm Carrie Dvorsets. Good morning, Chairwoman Bonds, staff, and others participating or watching today. Going to try to stick to 3 minutes-ish. The purpose of my testimony today is to discuss and testify against Bills 24-0239 and 24-0240, the Homeowner Association Strengthening Support Act of 2021, and the Condominium Association Strengthening Support Act of 2021. By way of background, I'm a lawyer in private practice in the district. All my clients, condo association, homeowners association, housing cooperatives are located in the district. There are several dozen of them. Been doing this for about 20 years. As it happens, a large number of clients are in wards 7 and 8. And my understanding is that there are well over 1,000, maybe 2,000 community associations in DC, housing probably between 1 and 250,000 DC residents. The proposed legislation, which clearly is well-meaning, imposes some sort of escrow requirement and training requirements along with reserve study mandates. And most of those goals are ones that the Community Association Institute, which I'm involved with but not testifying on behalf of or with the blessing of today, not that they disagree with my testimony necessarily, but this legislation as proposed will not have the desired effect and would cause total chaos and confusion and uncertainty due to lack of clarity, purpose, specificity, indications of who is to do what, who will bear the cost, who an escrow agent must be, what the purpose of the escrow account would be. The bills would cause, probably in all likelihood, cause lending to HOA or condo unit purchasers to either cease or become very confused. The legislation doesn't even say who needs to put these fees in escrow, who the escrow agent is, what the escrow agent's instructions are, and how condo associations are supposed to pay for example, the unit owner's water, which is often thousands a month, and other costs that they have to regularly pay. I don't know, no one I've talked to about this bill knows what its purpose is with respect to the escrow. Perhaps the council members who advanced it meant reserve account if they were concerned about structural issues and ensuring that reserve studies are conducted, which I'm in support of in some fashion. But as written, unfortunately, not just my opinion, but many other practitioners, management companies, and clients and colleagues with whom I've discussed it, the legislation as written will propel condo associations and homeowners associations into the Wild West, flying aimlessly into a statutory lending and community governance framework, which would contain inconsistent and directly contrary laws, contractual obligations, and other obligations. How, as I touched on moments ago, will community associations pay operating expenses such as water use, a pass-through expense, among other many pass-through expenses, including trash, insurance, landscaping, security, cleaning services, snow removal, management company, accountant, professional fees, etc. If funds are held in escrow, what is the purpose of the escrow? Does the council mean reserve account? What amount goes into escrow? Special assessments, all assessments, fines, reimbursements, income from renting out the party room, monthly assessments, accelerated assessments? What are the instructions for the escrow agent? Who will serve as escrow agent? Who will compensate escrow agent? And why is an escrow account more desirable than a reserve account or a separate operating account? What problem or problems is this legislation associated with escrow trying to address? I don't know. The legislation's biennial training requirement doesn't capture the terms of office of board members and officers. Also, many associations don't have enough willing volunteers to serve as officers or directors because they are unpaid. They have to run for office. They have to spend a great deal of time dealing with everyday community association issues. They're exposed to liability, claims, and complaints, and now they have to do a training. I think that will chill volunteerism. I'm all in favor of some level of training, but as written, it doesn't explain who will train, how will it be trained, why every 2 years, and what happens if someone refuses to go to the training but was nonetheless elected? Are they not a legitimate officer or director? Who's going to replace them? The legislation also runs contrary to many associations' governing documents and existing DC law concerning condo fee payments and how to apply those payments. Also, homeowners associations, as opposed to condo associations, don't tend to share structural or roof components in common. So if the purpose of the legislation is to ensure sufficient reserve funds in place for structural or emergency issues, that legislation doesn't make a ton of sense for HOAs, which are separated homes which don't share much with each other. We'd be happy to work with the council to figure out what the legislation seeks to accomplish. But at this point, no one I've spoken with about the bills understands them as written, much less what the escrow components say, do, mean, or trigger, who would be escrowing, what funds, and toward what end. As an aside, I am the chair of a committee that for the past couple of years has been drafting a homeowners association statute in the district. The district, unlike probably every other jurisdiction or the vast majority in the country, states, I should say, doesn't have a homeowners association law. And we plan on proposing one based on the model law of other states in 2023 to the council. It seems appropriate to potentially integrate some of the council members' concerns who have advanced this proposed legislation into that act, because right now this law would require homeowners associations, which have no laws or nearly no laws governing their existence in the district, their formation or their operation. And then there's just suddenly a law that says you got to escrow money, as opposed to a comprehensive Condo Act-like law that these concerns could be integrated into based on the Model Act or otherwise. So I request that the council members who have advanced this proposed legislation get with the experts. There is not necessarily a problem with much of this legislation as it may be intended, but as written, it will create chaos, confusion, and be a nightmare. Thank you.
Thank you very much for your testimony. I appreciate it very much. We wanted to make sure that the bills had an opportunity for comment from the community. So I'm glad to hear your comments. I just have a few questions, and maybe as you are thinking about what you're putting together as it relates to the homeowner association, I want to make sure that at least you are able to answer these questions, such as why a mortgage lender might be unable to collect homeowner fees in an escrow way as they currently would be collecting, let's say, insurance or property taxes. Just wanted to put that on your radar. That would be one area we would like to see answered. And then what happens to a homeowners association that is unable to collect fees from its members, and what tools can be used to enforce the fees, and how will the bylaws for a homeowners association be used? And then if you have information regarding how other jurisdictions pass requirements for homeowners officers to receive maybe management training or to be advanced for election as officers of such an association. I think those are some of the questions that we have.
So thank you, Chairwoman Bonds. On your first question, the way the legislation is written, it doesn't say who is escrowing the money. So if the intention is for the mortgagee to escrow money, I don't have a strong dog in that hunt because I don't represent mortgage lenders at all, and I represent community associations. In my view, if a mortgage lender were, if the idea here is to, in addition to the law requiring unit owners to pay assessments, the mortgage lender must, like with property taxes or homeowners insurance, escrow a certain amount, charge their borrower, and create an escrow as a lender. If that can be articulated in a way that makes sense, and the lenders lobby whoever they are, and other stakeholders can opine on the practicalities and the realistic possibility of it, I think that would benefit homeowners associations and condo associations. I don't know what the trigger would be for how much they need to collect, or whether there's a distinction between HOAs and condos, or whether what the trigger would be for the release of these escrow funds. Certainly it's not a replacement for the payment of condo fees by a unit owner. That would be absurd for, among other reasons. Lenders would have to communicate with thousands of different community associations in the district. What are the fees now? Who do I contact? Who's the new board member? That would be unwieldy. But perhaps there's an amount of assessments that would protect unit owners and associations, because the associations are the unit owners. This is a nonprofit governed by volunteers. 100% of their income generally comes from assessments, and 100% of their income is spent on the community, including and especially what the unit owners themselves use, including water. So if there is some concept of mortgagees being required to escrow funds like with property taxes, one would think that they would be incentivized to do that anyway to protect their security interests. But legislating that on some level, it certainly shouldn't replace the obligation for an owner to pay condo fees, but legislating some portion of the assessment to be escrowed could work. It's just not my expertise associated with how the laws governing lenders works in the district. On the second issue of associations' inability to collect assessments, I mean, that's a problem, because the association, for a couple of reasons. One, associations which don't have significant resources have to pay lawyers. Some lawyers are willing to be creative with respect to their fees, but the council recently passed legislation capping, at least if the association has to sue a unit owner, capping the legal fees for the vast majority of cases at 15%. So that didn't help, because these are just pass-through costs borne by unit owners and that they can't pass on. Very few lawyers are going to be able to sue and win and collect for 15% of the $4,000 that's typically owed. But that's legislation that exists. There are carve-outs in 2023 for hard to fight cases, or otherwise giving the judges some discretion. But the default is 15%, and that's not helpful. Indeed, these organizations, which are passed through, should be able to pass on all expenses caused by someone who's not fulfilling their duties. But the way a condo association chases after an owner for non-payment of assessments is to sue them or to foreclose non-judicially on them. Those are the only formal remedies. Sometimes the association can go to the lender, and sometimes the lender will pay some amount. Sometimes it'll pay the full amount, and often it'll pay nothing and say, go foreclose. And then the association has to shell out $2,000 in expenses alone, not to mention legal fees. So it's a cash flow issue, especially in Ward 7 and 8, for these associations to do anything about unpaid assessments. With respect to other jurisdictions and their training requirements of boards, I claim ignorance. I have no idea what other jurisdictions require by way of board and officer trainings. I'm not aware of any such requirements, but I don't claim, just because of my lack of awareness. It's certainly something that couldn't hurt and could help with some level of training. I just don't know. I would just like the sort of industry and stakeholders to be part of the conversation, which they haven't been yet, associated with mandating trainings, because my testimony is not on behalf of for-profit organizations that have their own their own sort of secret agenda. The agenda here is simply condo associations, which are nonprofit, all volunteer organizations, to function properly and without laws imposed that are nonsensical. And unfortunately, as written, it's kind of nonsensical. But the goals unto themselves are not misplaced. It's just that we need to write it correctly and maybe compare with other jurisdictions and work on it together to implement what makes sense.
Well, I thank you very much for your comments. And my point in mentioning these areas was to say, I hope that the law that you're putting together will include some of these areas, will at least, define these areas, give us some answers. I think that would be very, very helpful. And of course, you're going to tell us in the law that you're preparing why the homeowners association would exist, what would be its powers and the responsibilities, very similar to what we have in the Condominium Act of, believe it or not, 1976. So we're trying to fix that now, as you heard earlier. And so let's see what the Homeowners Association Act might contain as you're pulling your ideas together. So we look forward to hearing from you on that. And I just have a few questions, since you also represent condominium associations. You mentioned that you want to make sure that the association, homeowners association members would be part of the discussion regarding the training of the officers. I guess that would be true also as it relates to condominium associations. Do you have any other particular concerns about condominium associations at this time as it relates to, of course, the bill we're examining, but just in general, because we're trying to improve the association, process?
With apologies, I want to fully understand the question, and I don't, and it might be because I blanked out for a second. The question is with respect to condo associations and this proposed legislation, or with respect to condo associations in general, what legislation should come down the pipe?
Yes.
Oh, okay. Well, there's one piece. So I'm not speaking on behalf of the Community Association Institute, but I am involved with the community, with the DC Legislative Action Committee, which is why I chair this HOA subcommittee drafting group. But with respect to condo associations, there's one issue that we have yet to bring to the council because it's relatively new and because of COVID and because of these other time-sensitive condo topics. But in 2017, and this is not about governance, but in 2017, the DC Council, admittedly with the involvement of the Community Association Institute, introduce and pass legislation that requires a condo association, when it is foreclosing, to choose whether it is foreclosing in a particular way, junior to the mortgage or not junior to the mortgage, based on the understanding, everyone's understanding of the law in 2017. But in 2018 and subsequently, DC Court of Appeals, DC's highest court, decided, essentially changed the law or the interpretation of it, such that the 2017 law, which added requirements for foreclosures in terms of language used and warrant or steps and information that needs to be contained on the notice, doesn't make sense anymore. It's actually it's nonsensical, it's irrational. So essentially it requires the association foreclosing to choose A or B on a foreclosure notice. But then 2018 and subsequently, DC Court of Appeals said there's no such choice as A or B. So that's a housekeeping issue, frankly, that I just need to craft with my organization a fix to. I don't think it'll be controversial because it is. But other than that, in terms of priorities associated with, in terms of what needs to be legislated, I mean, I think that the condo warranty legislation doesn't get us fully there, and this has been discussed and over discussed, so I'll keep it to 20 seconds. But the condo warranty claim process and law is broken. It is a nightmare. And so whether this will fix it or not, it probably will help a great deal. It won't fully fix it, but it is currently, for my clients, in terms of affordability, predictability, process, consistency, and resources available for DHCD, it is become a joke. And it's not DHCD's fault. They just haven't had the right guidance or the right funding. But that warranty process, the timing, and the requirements in the first few years of existence of an association, that is the most precious time. And while some lawyers may represent the good developers, for some reason, most of the developers I've encountered are not the good apples.
All right. Well, I would love to hear your opinion on the warranty bill, and I have time if you have time, but I know that I would much rather have your opinions in written testimony. So if you would submit something, that would be helpful.
Yeah, to be frank, I reviewed Todd Sinkin's testimony and even gave him feedback on it. So his testimony envelops my opinions.
Excellent. Thank you. Thank you so very much. Thank you for your testimony today. All right.
Thank you, Chairwoman.
We will now move to the next panel, which is Michael Greer, Chair of Issues and Legislative Affairs Committee, Ward 8 Democrats, and Yada Ford, Community Associations Institute, and Carla Perkins, a public witness, and I believe it's Eco Tambi, Chief Operating Officer of the Potomac Place Condominium Unit Owners Association. And so welcome to you all. Happy to have you, and we'll start with Mr. Greer.
Thank you, Chairperson Bonds. Give me just 1 second.
Sure.
It's weird to be doing this from home. Good morning, Chairperson Bonds and members of the Committee on Housing and Executive Administration. I am Michael Greer, co-chair of Issues and Legislative Affairs for the Ward 8 Democrats. It's my privilege to appear before you today and testify in support of the Housing Association Strengthening Support Act of 2021 and the Condo Association Strengthening Support Amendment Act of 2021. As a leading voice in our community, we believe it is our imperative to speak out and support legislation that creates a positive impact in Ward 8 and more broadly in our city. These two bills work in tandem to improve community resources and seek to bring equity to neighborhoods in Ward 8 that are all long overdue for investment. Implementing these bills will bring resources to homeowner and condo associations and allow them to invest in their properties and raise the quality and standard of living throughout Ward 8 and the city. Across our ward, we see the value of community-driven equitable development, often driven by your leadership, Chairperson, and its impact to change lives. When talking to our neighbors, we hear the same lines over and over again. The city is doing a lot, but when will it impact me? When will I see change? As you know, Chairperson, the answers to most community problems are in the community. And the proposed legislation helps communities have the resources needed to address the problems and implement change. As we continue to develop, neighbors across the ward must have the resources they need to enhance their corner, their little part of our city. We see these bills as allowing more neighbors to drive the change they wish to see in our communities through community-driven processes grounded by residents that live and care about their communities. We do understand that there are administrative challenges facing the implementation of this legislation. However, we see these bills as a first step in enhancing support for homeowners and condo associations. The intent of this legislation is sound and supported by our organization. The need is not only real, but palpable in Ward 8. In deciding whether to support this legislation, we spoke with residents who shared stories of associations who went insolvent or dissolved entirely because of a lack of resources. I heard stories of leaking roofs, dangerous stairs, and more infrastructure problems that are the shared responsibilities of owners of the buildings or communities. Our homeowners and condo associations will have the will to address the needs of the communities they serve. They now need the resources. The tragedy we witnessed at Chaplain Towers in Miami gripped the nation and created a clear imperative to ensure safety and security of shared properties across the US. In response, jurisdictions across the country are seeking to enhance inspections and safety. A safe home should be the right of every resident of the district. A critical linchpin in ensuring that those rights are homeowners association and condo associations who need the resources to ensure safety, strengthen communities, and improve lives. By creating a more streamlined process in collecting resources, we empower associations and communities in Ward 8 and across the city to go bolder and shape our city for the better. Again, the Ward 8 Democrats support the intent of these bills and look forward to taking this first step and working on future improvements to legislation to strengthen our associations. Thank you.
Thank you very much, Mr. Greer. Next, we'll hear from Ms. Ford.
Thank you, Council Member Bonds. I am happy to be here. My name is Yaida Ford. I am testifying on behalf of CAI, the Community Associations Institute, and the DC Legislative Action Committee. Carrie Dvorsets is one of my colleagues. We actually sit on the HOA subcommittee that Carrie was telling you about together. We worked on that committee for the last few years. I'm also a Ward 8 resident, so I'm very unique to the LAC. I'm the only one who sits on the DC Legislative Action Committee as a Ward 8 resident and as a lawyer who represents communities in Ward 7 and Ward 8. I also represent, communities in more affluent parts of our city, but I have a very unique perspective because I do both, and I also live within my ward. So I'm talking today about B24-0240, the Condo Association Strengthening Support Amendment Act. I won't repeat some of the things that Carrie mentioned about the HOA Act. It's a little redundant, but I do want to echo CAI's concerns across the board and the things that we think are great. I mean, first of all, CAI applauds the council for recognizing the need for training for board members of condominium associations. As a lawyer who represents condo associations, that really is a sticking point. Training, we believe, will equip board members with the tools they need to effectively manage the interests of owners within their community. Board members are volunteers. I know I'm also serving as a president of a condo association now, and I have switched gears from being a lawyer into a board member. I know how difficult it is working with the group of people who are volunteering who have no idea what is going on with the condo association, how to manage it, what their responsibilities are, the level of accountability, what a fiduciary responsibility is. I mean, these are things that they just simply do not know when they volunteer to step up. And so we think the training requirement is a good one. We also agree with the reserve study requirement. And because, as Mr. Greer noted in his testimony, the most communities are underfunded, whether they are affluent or not. We saw that, like he said, with the South Florida incident. And reserve studies really educate owners on how to fund their needs over time. That's what a reserve study does. So we think that that is a good thing. However, what if this legislation is written, if it's implemented in a certain way, actually undermine some of the bill's objectives? And that's what CAI wants to bring to your honor's attention. If we want boards to manage their money better, so that they have money to spend on important things, we do think that the escrow requirement would undermine that. We think that the cost of the escrow requirement is something that may not have been considered when the legislation was drafted. Who would be the agent? And again, we're talking about communities that are already struggling. And so how would that escrow account be managed? Also, these are non-interest bearing accounts. So there's supplemental income that comes from interest bearing accounts that associations need when a healthy bank balance is maintained. Let's just put it that way. Also, how will the escrow account work with associations who have a property management company that is responsible for paying out the community's bill? Some associations are self-managed, but then they have their own bank account that they oversee. So how will the escrow account interplay with the role of a property manager? And we do think that if it's money that can't be touched, then how will the community get its needs met? How will they meet emergency needs if a pipe bursts? How will they actually be able to respond to their fiduciary obligations if there is money that's in an escrow account that they can't get access to, particularly when they're already underfunded? So we think the reserve study requirement would be good, but the escrow requirement might undermine the actual goal of the reserve study. Just so the council is clear, the reserve study costs money. I just ordered one for my condominium. It was almost nearly $4,000. And so that costs money. It's a worthy investment. We need that. But it, we were surprised to see we only have 1 year left on our roof, and that cost us $75,000. Right. So we need access to the money that we have. We have a property manager that we work with as well. But having any pot of money that is untouched or untouchable for the board to do and some of the things that are needed, some of the unforeseen things, would undermine the stability and the financial stability of the association. Lastly, I want to talk about the training piece. While we do think it is a good idea, the question is who will pay for this training? Do the trainers need to be certified? Who would a board member be disqualified from serving if they had not yet had training prior to sitting in their seat? So there are a lot of questions that we would have around the training requirement and its implementation and how it would affect boards going forward in the district. So those are some of the things that we're happy to engage with your office, Councilmember Bonds, to make something work with this bill so that it doesn't undermine the stability of our communities, particularly those in Ward 7 and Ward 8. I'm here for questions from you.
Thank you. Thank you very much for your testimony. Ms. Perkins, we can hear from you now. Thank you for being here.
Thank you, Councilmember Bonds. I appreciate this opportunity. Again, my name is Carla Perkins, and I own a unit in a condominium complex that currently has over 300 units and is located in Southwest DC. I serve on my condo board, and I have served now for over 10 years. But I come to you today as a condominium owner in opposition to B24-0240. As it is written, it is unclear what problems this bill is actually seeking to remedy. Is it to address the rare instances where bad board members mismanage association funds? Is it to address misguided boards who don't understand the importance of a reserve study? Is it to assist ill-equipped board members to educate them about how to actually run an association? For me, the goals of this legislation were just not clear. But on the flip side, it appears that this bill may punish all condominium owners in the District of Columbia by subjecting them to a makeshift receivership via this escrow requirement. This bill essentially takes the authority of a condo association directors, their authority and responsibility to manage the condo's finances and to direct the business affairs of the condo. It takes those responsibilities away from the directors. This bill appears to implement a somewhat ambiguous reserve study requirement. And in general, the bill seems to harm all condo owners, making it more expensive to actually own a condo in the District of Columbia. For me, the most onerous part of this bill appears to be the requirement for unit owners to pay association fees to an escrow account. Association fees are needed and used to pay for ongoing maintenance, daily operations, and future expenses. This bill appears to call for an escrow account, but there are no details about who, how, and when the escrow account will pay the association bills. Just to put this in context, my condominium pays about $14,000 a month for our water bill. And DC Water charges a penalty of 5% if that bill is paid late. So it is critical for this legislation, if you're pursuing an escrow account, to establish a process to ensure that bills are paid in a timely manner. I mean, just the water bill alone, if paid late, would be an additional $700 fee that the condo association would have to account for. So my association also works with an investment advisor, and we earn money on our reserve and replacement funds. We earn a significant amount of money in interest for these reserve and replacement funds, on these reserve and replacement funds. Escrow accounts typically don't earn interest. So my association, as well as others, would then lose out on a source of income that we use and need to supplement our condominium fees. So for me, this legislation raises a question: why should a well-functioning condo association led by qualified directors be forced to relinquish control of its finances and its business affairs? So I see my time is up. I wanted to thank you for this opportunity. I do support board training, certainly, and I understand the mandate for reserve studies. Not everyone appreciates or understands the significance and importance of having a reserve study, but my condominium certainly does, and I certainly do and appreciate the aspect of possibly having board training, especially once we know what type of topics will be covered and who will pay for the training and how officers will certify that they've actually received training. But in sum, this bill casts an unnecessarily wide net to include fully functioning condominium associations, and it would be better served if this bill were more narrowly tailored and provided with details that help those associations who actually need assistance with governing. But thank you again for the opportunity to testify today.
Thank you very much for your testimony. You covered a lot of the boardwalk, so to speak, and I appreciate that. Thank you. Since you are in place and operating and have operated for a number of years, thank you for your insight on the bill and just in general as to sounds like what makes a good condominium association. And congratulations for that, because I know these voluntary jobs, that's very important. Thank you so much.
Yeah, they don't pay much. So.
No, they don't, I'm sure.
Thank you. Thank you for your service.
Sure, thank you. Ms. Tumby, you're next.
Yes, ma'am.
I see you in the queue.
Yes, ma'am. And thank you so very much for the opportunity to testify today. I think my testimony is going to follow suit, as you've already heard from the rest of the panelists here, to comment on the escrow and also to comment on the board training and on this bill B24-09. And so my name is Ekoke Tambe, and I'm going to be speaking from a management point of view. I'm a 31-year common interest community manager who has practiced in the DMV and currently the chief operating officer of a 300+ unit condominium in Ward 6, and also proudly a DC resident owner. I come before you today to strongly advocate for tabling this bill and removing it from consideration until such time that the sponsors have had occasion to consult with expert stakeholders and practitioners in the condominium management industry. The reason is because in reading this bill, my manager's spidey sense tells me that the bill sponsors are attempting to protect unsuspecting homeowners from uneducated boards that have failed in their fiduciary duties to proper fund reserves. I could be wrong, but that's how I read it. However laudable this might be, the bill is, as it is written, would only work to hinder operations in well-functioning condominium associations and strengthens not the ones that will be, that this bill appears to want to protect, as Ms. Perkins has already alluded to. Condominium associations have only assessments as their form of revenue, and condo governing documents have established mechanisms to guarantee collection of these funds. This bill, which amends the DC Condominium Act of 1976, superior in hierarchy to condo bylaws, as I say it, and I quote, requires association fees to be paid into escrow account, but does not address the mechanism by which the escrow agent, whomever that will be, how that person would ensure all payments are made. The bill also fails to indicate a deadline by which fees are to be paid. There is no mention of the association governing documents or how the requirement to pay fees into escrow will be managed. How will expenses incurred by the association be paid? In other words, what are the procedures for payment to be effectuated if funds are held in escrow? The bill also, and I quote, requires that each association must document a decision on the use of reserve study, that is an in-depth analysis, on-site inspection of an association's assets, and whether the reserve study cost would be required to be a component of the association fees. First, it is very unclear as to the intent of this sentence to me. Does this require board simply to include a budget line item to pay for a reserve study? If so, at what intervals? Does it require the association to obtain an analysis from an engineer or a similar expert for each repair or replacement being made from reserves? I am wholly supportive of condominium performing a periodic reserve study as a best practice. However, as drafted and as is becoming a litany, this bill simply creates ambiguity regarding whether a reserve study is performed, how frequently, and how expenses from reserves are to be made. Very commendable as well, the provision for officers to have biannual training, but leaves a portion of members of a large board in perpetual ignorance. The reason I say this is because there's a difference between officers and directors as most condominium instruments are written. For example, a 9-member board with 4 officers, meaning president, vice president, secretary, and treasurer, will have the majority of the board exempt from your mandate of biannual training, meaning other directors who are not officers are not included as this bill is written in the training provision. The obvious questions of who will administer the training and what the curriculum would be is lacking in specificity in this bill. What are the District of Columbia good standing requirements pursuant to board training? That question should be answered. Honorable Chairwoman, as you have heard from most of the testimonies on Bill B24-0940, there are problems as it is currently written, and the recommendation to meet with stakeholders and experts in the community association space is still very open. We are willing, able, and eager to be of assistance to make this a better bill that would work for most everybody, which we think is the intent that the committee is wanting to see happen. Thank you so very much for the opportunity to be here.
Thank you very much for your testimony, and that's to the entire panel. I think I recorded your comments well. I understand where we're headed on this, and it looks like we need a little more work on these 2 bills. But the intent, as Mr. Greer said, is there. The intent to make those who particularly live in your neighborhoods, Ward 8 and 7, more whole as the transformation of the city housing stock takes place. So I appreciate that. Mr. Greer, you want to comment?
Yes, council member, I just wanted to say a special thank you to you as well as your staff for holding this hearing and allowing this discussion to move forward. As you know, the Ward 8 Democrats reached out to you directly, and I just wanted to say thank you so much for your willingness to hold this hearing. And we, again, see this bill as a first step. We understand that there are some challenges that are outlined currently by other persons testifying. However, we believe that this is a good first step, and we are encouraged and look forward to the results of these continued discussions and look forward to attending another hearing where we have the opportunity to speak in support of the advancement of communities in Ward 8 and across the city.
Well, thank you. Thank you very much. That's a very important statement because, as you pointed out, the areas in Ward 7 and 8 are where we have some of our more undeveloped land, and so there's the likelihood of having more condominiums and homeowner associations in your neck of the woods. And we want to make sure that we do everything we can to have processes and procedures in place so that we bring on a good quality of life. So thank you very much for that. I think all of you have been very clear as to your concerns about the bills and what you'd like to see, and the effort that you would like to see, in fact, moving forward. And so I commit to speaking with the authors of those who wrote the 2 bills to see how we can move forward and maybe come back to the table with some of the ideas that you've shared today and be more explicit with that. I also am going to look to the Community Association Institute to provide us with I think they're already in the process of drafting language for the homeowners association. So that could be very exciting. And as Mr. Greer said, we're going to continue this dialogue because I think it's very, very important. These types of dwelling units are very helpful to the community, given that we cannot or we are limited as to the height of our residential structures. So we have to be careful with that. So it means that we all have to learn to live close together and make a community wherever we are living. And so I'm looking forward to working with you all on this into the future. And thank you very, very much for your input today. I really value it. And so we'll take just a 10-minute break, and then we give us time to turn to our government witness, which we have a series of questions to ask and see how they can embellish what we're most concerned with today. So thank you again. COHEA, how are we doing?
Ready whenever you are, council member.
Oh, okay. All right. I am ready. Okay. Let me get to my comments. We will now hear from the Director, Department of Housing and Community Development, who will present our government testimony, Mr. Drew Hubbard. Mr. Hubbard, welcome. We're happy to have you today.
One sec to.
All right, we're ready when you are.
I got it. Yep.
All right. Okay, and we will swear you in, please. All right. Do you swear and affirm that your testimony and any statements that you make before us today to be truthful and complete?
I do.
All right, you can begin when you're ready. Thank you.
Thank you. And good afternoon, Chairperson Bonds and members of the Committee on Housing and Executive Administration. I am Drew Hubbard, the Interim Director of the Department of Housing and Community Development. And I'm pleased to be here to testify on 3 bills that are under discussion today. As you know, Chair, DHCD's mission is to produce and preserve affordable housing for low and moderate income residents and revitalize underserved neighborhoods in the District of Columbia. To fulfill its mission, DHCD oversees, for the points of today's conversation, oversees the condominium registration and warranty process, as well as a myriad of other programs designed to stabilize families' housing and increase homeownership, including in homeowner associations, condominiums, and residential cooperatives, often referred to as common interest communities. As you're also aware, Chair Bonds, Mayor Bowser has brought together a historic Black homeownership strike force, of which we are both members. This strike force, of which the work is ongoing, is charged with developing publicly supported recommendations that address racial disparities in homeownership and household wealth. We've already begun to generate novel ideas that should make homeownership in the district more attainable and equitable. I would like to discuss the bills today within the framework of the strike force and the goals of increasing and strengthening homeownership for all district residents who have historically faced discrimination in the housing market and continue to face adversity today. I would like to begin my discussion with the Condominium Warranty Claims Clarification Amendment Act of 2020, B24-0934. The current law requires condominium developers to provide buyers with a 2-year warranty against structural defects in units and common areas. To fund the warranty, the developer must post a bond, letter of credit, or other form of security with DHCD based on the construction or conversion costs for creating a condominium. If a buyer or condominium association perceives a structural defect and cannot independently come to an agreement under the warranty with the developer, the buyer can submit a claim on the warranty security to DHCD. This bill, amended after fruitful cooperation with your committee staff and advocates for both condominium unit owners and developers, seeks to codify and improve the current claims process, which was defined by the lapsed Condominium Warranty Claims Clarification Emergency Amendment Act of 2020 and the related legislation. The first step in this process is for DHCD to determine whether a claim has been perfected. For a claim to be perfected and for the district to award funds from the warranty security, a unit owner or association must provide the following. 1, notice to the district indicating that it is filing a claim against the warranty security within the statutory warranty period. 2, documentation prepared by a qualified expert providing their opinion that a building component is structurally deficient as defined by the Act. 3, cost estimate for the repair, replacement, or renovation of the structurally defect building component. And 4, copies of correspondence between the claimant and developer, who is referred to as the declarant, establishing the declarant's failure or refusal to repair, replace, or renovate the structurally defective building components, and establishing sufficient notice to the declarant that a claim has been made against the warranty security posted with DHCD. Based on these criteria, DHCD issues an administrative determination of whether the claim has been perfected. If perfected, DHCD is able to pay the claimant the amount of the perfected claim. However, within 30 days of that determination and before payment can occur, both the claimant and the declarant have the opportunity to contest the DHCD determination at the Office of Administrative Hearings, or OAH. Unlike the DHCD process, which is purely administrative, and a determination that establishes that the criteria listed above have been met, the OAH process is a quasi-judicial proceeding, and it reviews the claims anew. Thus, is also not an appeal of the DHCD's determination, but in other words, both parties can make a fresh case, providing the OAH administrative law judge with the evidence and the arguments of their choosing. It is also important to stress that at any time in this process, even after the warranty period is concluded, either party can bring suit at OAH or in another court of competent jurisdiction. DHCD will hold the warranty security until all such legal proceedings commenced during the warranty period are completed. The current process is designed to be more efficient and to provide more clarity regarding the developer's responsibility to address warranty claims. Before the current process was established, the ambiguity of the statute often led both claimants and declarants to view the mayor as the primary means to address structural defects, pay for repairs, and honor the warranty. Often this resulted in a cloudy understanding of the developer's responsibility to address all claims and put the mayor in a position, of brokering a settlement and deciding a claim in a lengthy back and forth process without defined time expectations. It also encouraged premature submission of warranty claims to DHCD that could otherwise be resolved by the parties. As a result, and prior to the passage of the Condominium Warranty Claims Emergency Act of 2020, in FY20, the department had 24 active warranty cases in its hands. Currently, we have around 12 pending claims. 8 cases have been contested and are under the jurisdiction of OAH, with most of these cases being resolved by a settlement agreement before a final ruling was issued by administrative law judges. The bill before you would permanently codify these changes and make further improvements and clarifications, including imposing clear timelines for both the mayor and the parties. Additionally, a key concern with the current statute is that it is possible for a developer to complete a project and not post a bond prior to conveying the units to new owners. This is because these two processes are not currently linked in the district's code. We expect that one of the amendments in the bill before you, which would require the developer to post a bond before the first unit is conveyed and require an escrow agent to confirm this or collect the bond before closing, will result in every claim having a corresponding warranty bond going forward. In summary, we strongly encourage the enactment of this bill, as it is based and improves on a process that has been successful over the past 2 years. The deliberative process your staff used to reach a consensus bill that will greatly improve the chances that low-income and historically excluded households will benefit from becoming homeowners. The enactment of this bill will provide greater clarity on the condominium process. I would now like to turn to the Homeowner Association Strengthening Support Act of 2021, B24-0239, and the Condominium Association Strengthening Support Amendment Act of 2021, B24-0240. Both bills, I'm going to take them together substantially, will require homeowner and condominium associations to provide greater transparency in their financial affairs, which would improve homeowner satisfaction. In addition, the bills will require internal conflicts within associations, would reduce internal conflicts within associations by requiring them to improve their operations and governance. Under the bills, officers of an association are required to, number one, undergo a biennial governance and management training, and 2, make a proactive and recorded decision as to whether to conduct an in-depth analysis and on-site inspection of the association's assets, known as a reserve study, And if so, to require paying for the study to be a component of the association's fees. We are supportive of both these provisions. DHCD has recently established a hybrid online and in-person property management course for common interest communities and small landlords that could fulfill this requirement. We suggest, however, that the recommended reserve study for associations also be made a requirement, perhaps conducted routinely according to a specific number of years based on best practices, and including an estimate of the anticipated major maintenance, repair and replacement costs needed by the association. Infrequent and significant costs for maintaining building systems such as roofs or boilers may be impractical to plan for in the annual budgeting process, potentially endangering owners' homes and buyers. In addition to these two requirements, I will note there's also language in the introductory caption for both bills introducing a requirement for homeowners to pay their association fees into an escrow account. While this text is absent from the text of the Homeowner Association Strengthening Support Act itself, it is present in the Condominium Association Strengthening Support Amendment Act, along with waiver for condominiums with 6 or fewer units. Beyond highlighting the inconsistency, I wish to note that this requirement raises several compliance questions over how the escrow accounts would be managed. And just noting that I was able to listen to the testimony of all the witnesses so far, and many of the concerns that we have been raised, but for the purpose of the record, I just would like to note them. And to begin, how the association will determine the percentage of the association fees to be paid in the escrow account is an initial concern. Whether association fees include late payments, and if this requirement would negatively affect the association's ability to readily access funds to deal with emergencies or other situations in which funds are needed quickly. Additionally, it raises concerns related to how penalties for associations failing to establish, or if they are abusing an escrow account, how that will be assessed. And in general, it's unclear what actions individual owners or others would have to take or seek redress under these two bills. As many people are aware, litigation is not always an ideal remedy for those in common interest communities because of the disputants are often neighbors who must maintain ongoing relationships. The bills may wish to consider establishing a mediation program or other alternative dispute resolution measure for common interest communities. Additionally, to further strengthen common interest communities within the district to prevent displacement, the bills may also want to cover the establishment of a reserve minimum for associations. This would help to provide clarity and financial stability. Finally, along with taking a closer look at these issues, the committee may also wish to consider these two bills as the start of a wider effort to address governance in all common interest communities and include residential cooperatives under the bill's umbrella. I think part of the discussion you've already had, Madam Chair, leads towards that as a potential way forward. Many of the goals of these two bills coincide with the recommendations of the Limited Equity Cooperative Task Force, the 2019 report, and other initiatives over the years. The issues addressed by these bills and the recommendations I've made are not easy to get to. Therefore, in closing, I want to thank you, Chair Bonds, and the Committee on Housing Executive Administration for taking them on and committing to making improvements to the bills as they are written. The DHCD staff is available to work with you and your staff and other agencies that are involved to ensure that the bills at hand are able to meet the expectations as presented. We would be happy to engage in a process similar to the process you followed to bring the Condominium Warranty Claims Clarification Amendment Act of 2022 to this point. Again, thank you, Chair Bonds, and a member of the committee for this opportunity to testify and your continued partnership. This concludes my testimony. What happened answering questions to explore making sure these bills meet the intentions.
Thank you very much for your testimony, and thank you for being comprehensive in your approach. I do believe that we are moving towards a common interest, bill that would take into consideration these various forms of common interests. And as I like to think of someone who certainly has promoted the cooperatives, that this is right on time. And as people are trying to live in community with using different tools, from what, our parents probably grew up under, where you rent an apartment or you buy a home and that's it. I think that it's well timed for us in the District of Columbia as we're struggling to make sure that all of our people are housed, and that they're housed in methodology that suits them and their lifestyle and their income. So I think that this is well past the time. Specifically, I have a few questions. I think you answered many of them already. And as you said, I think our panel has gone to great lengths to accentuate some of the concerns that we would have. But I wanted to know how many claims are filed with the warranty bond each year. I know you gave us a number where you said you're down to about 12, 8 of which are being contested. But on an average basis, annual basis, is it a couple of 1 or 2, or is it more?
I think on average, we get about 20 to 30 filings a year.
You do. I see. So with the proposed changes in the Warranty Claims Clarification Amendment Act, do you anticipate that number increasing?
No, actually, I think, and again, we'll reiterate, working with your staff on the emergency versions of this over the last couple of years has really put in place a framework where you have a process that is easier to navigate. It's easier to know where we fit in, our role is when things are handed off to OAH. And our goal always is number one, and it's worth mentioning, it gets to us in this process if the parties cannot come to an amicable solution to make these needed repairs. So our goal is always to make it so that we have less that actually need to come into this process. And if they do, they can navigate it quickly. And if they need to get to court for ultimate judgment or settlement, that they can quickly get to that process also. We, just to mention, just for context, of those 20 to 30, we register about 300 condominiums every year.
So when you say you register, those are new condominiums coming online. So approximately how many do we have in the city as of this year? I'll say this calendar year 2022.
Let me check on that. I'll get you an exact number. Asking staff just to pull it up for us.
So Mr. Hubbard, your 300 number, that is actual buildings as opposed to units, correct?
Yes, that's actual buildings.
Do you also keep track of the number of those registrations that are conversions as opposed to some new construction?
Yes.
All right. So that we don't take too much of your time, would you just provide us with some information within 10 days, please, that would articulate the volume and the volume on an annual basis, and how many are conversions, and the number of units that are contained in each of those condominiums that are registered with you annually. That would be very helpful.
Absolutely, and I'm only for making sure we have a complete number and try to actually work with our Office of Tax and Revenue to make sure that we are right. I know that in-house we have data going back to 2017, and since 2017 we've had over 1,300 condominiums registered since 2017.
All right, and I think prior to that we were showing about, if I'm not mistaken, maybe 4,000.
It sounds
so-
right, and I'll get you an exact number.
Yes, all right, that would be fantastic. Thank you very much. Now, the bill requires the mayor to establish a financial assistance fund to support condominium owners that need assistance for, those various things, attorney fees, inspections, cost estimates, and what have you, related to the warranty claim process. How much money should reasonably be, and I guess anticipated to accumulate in this fund, and what would be a reasonable eligibility standard for receiving the financial assistance?
And again, I definitely listened to the discussion on this that happened a little earlier amongst the public witnesses. I don't have an exact number right now, but I will say this. I do agree that need has to be factored into this, especially when you're looking at condo associations and condo owners, that may be in disadvantaged categories or maybe lower moderate income owners. I think we need to take that into consideration. I'll say this in a blanket sense, both this and some of the other questions that were raised about specificity, we definitely agree and know that, upon this passing, we also want to work with you to make sure that we promulgate regulations that really pin down the rest of the processes and specificity that's really going to make this impactful. So I think that's going to be proper to be included in the deliberations under the regulations that we will work to quickly get promulgated after passage.
Oh, I really appreciate that, because one of the issues you heard earlier is whether or not this 10% of the value of the development it's the right warranty bond, value, or should it be per unit fee or some flat fee? And then we talked a little bit about construction defect insurance, which coming out of the construction industry for a few years, I can tell you there certainly is bonding available for those kinds of situations. And so I just wonder if there isn't a way for us to look more closely at that construction defect, insurance. So, got a lot of questions. I agree with you. We really do need to narrow down what we can do as a community to make the opportunities more available to those who are in condominiums and homeowners associations, and of course the co-ops as well. Can you how do you see the reserve study really helping or benefiting those that are in the common interest dwellings?
I mean, I think it could be a very powerful exercise and tool in talking to just kind of anecdotally some folks who sit on these types of boards who already do it. They have told me it just really helps with future planning and thinking about the long-term health of their buildings. So, just as kind of any other facet of life here in the district, you have some boards and some members that are more sophisticated than others. You have some that have levels of expertise, and potentially this just exposes another tool that could help the health of these buildings going forward. So I think it could be a very impactful tool.
All right, one of our concerns is trying to understand the kind of structural defects most commonly result in a warranty claim. Do you have any data that would help us to understand that you could share?
Yes, and let me provide that to you as part of our follow-up, and
All right.
we will pull out the most common ones.
All right, that would be I think a big help. Let's see. I think your testimony pretty much covered some other questions that we had. This is a big area. The big area is, when should a warranty bond be posted? You kind of touched on it. You're driving us to understanding that maybe it's most appropriate at the time that a developer decides, I'm going to make this a condominium. Is that kind of what your thinking is now?
I think so, and just again raising the point that I made in the testimony. If once the horse is out of the barn, you know you're going to have to put a lot of effort into trying to get that warranty posted if they've already sold the units. All right, so I've heard some of the concerns from the industry side that were made today, and I would counter by saying, you know, if you're looking at construction or conversion, you've already secured that funding to do it. So at the point you're looking to go forward with that project, I think it's proper to have the warranty kick in there.
Area that we have talked a lot about, and that is this area that you're very familiar with, and that is where the government had to step in with funding for those parties that were harmed. And because the warranty was not, you know, robust enough to take care of the needs. So can you give us some insight as to what you think this fund might look like, and the value of it, and how it could be used, and how it could be regulated?
Meaning the assistance fund?
Yes. Mm-hmm.
I mean, I'll speak to it generally, just about the need and the potential of it. Again, going back to looking at this as, you know, through a frame of equity. If we're looking at low and moderate income residents, looking at homeowners that may come from a disadvantaged background, that may not have the upfront resources to pursue their legal claims, you know, we provide this resource in other areas, and I think it's a good consideration, especially when you're talking about helping someone really safeguard one of their greatest assets, their home. And again, in concert with the theme and the mandate behind the Black Homeownership Strike Force, not only when you look at creating new Black homeowners and then just homeowners in general, I want to make sure that the homeowners here can stay here, that they're not forced to look at other accommodations either in the city or, you know, God forbid, outside the city, because they've run into these difficulties. If we can help, you know, stem or provide some resources on the front end that help them really go after perfecting their legal claims.
You know, I wanted to ask, as you talk about the Black homeowners strike force and the work that we've done, I just wondered if you are seeing the need for there to be the general fund that will help, and maybe another fund that would particularly help Black homeowners. I know it's a tough question because we try very hard to make sure we are in equity, you know, engagement, and that everyone is given an opportunity. But we do recognize through the Black Homeowners Fund that there are some very specific wrongs that we're trying to, you know, right in today's society.
I mean, you know it, sitting in those meetings too. This is something we've, I won't say struggled with, but we've taken a very pointed discussion path on this to make sure that, you know, if we say we're trying to get to equity, there's certain tough decisions you need to make about who, what, how, and why we put these resources in place. So, I mean, I'm definitely willing to, as we get to a point, again, putting the regulations out, that's something we need to consider. And I'd love to work with you on figuring out how we can do that in a way that you know, gets us where we want to go and still is legally sufficient.
A couple of our witnesses this morning have questioned the capacity of your agency to follow up on the warranty claims legislation in particular. And I guess to some degree as to what would be needed in order to bring all of the common interest properties into some sort of symmetry. Are you in need of claims adjusters as an example, you know, experts that can help with that, or give me some idea as we move closer to budget, but right now, if you had a dream.
So again, and I'll reiterate by saying it this way, and I don't mean to sound harsh, but one side of this equation as a tactic probably would like to extend this out into perpetuity. All right. Again, by simplifying the process, by putting definite timelines on it, by making sure we have tight definitions, we are streamlining so we don't need as much as far as resources to have to chase, you know, the back and forth that's happened over the years around the process before this was put into place, and really made it untenable to try to have quick resolution of these things. I think going in this direction is going to allow us to really push these things through on a faster clip. And again, the thought and frankly, what happens on most of these that never reach us, we want to make sure that, again, without the kind of perverse incentive to kind of string this along for a long time, I think you'll get more amicable resolution of some of these claims.
All right, well, you know, a couple of our witnesses also have talked about how easy it is to mount a claim when there's been, number one, bodily harm, or number two, when the use of the facility, being the home, is incapacitated. And so we're hoping that this third condition, which is, you know, outstanding code violations, will also be addressed. Have you given thought as to what language we need to have available in this legislation that would address code violations, major code violations?
And again, I really think, especially for that piece, really digging into that and putting specificity in regulations is going to be a better approach. But again, we'll work with you hand in glove to make sure that those type of definitions are in the regulations.
Well, we appreciate that. And if you would, as a second request, if you would just, you know, send us your ideas as it relates to the types of code violations that would fit under this warranty process, this revised warranty process. And just keep in mind that this process that we are using today, because the temporary has expired in January of 2021, is a process that's been around since 1976, which is when we began rent control in the city. And so much has changed, as we all know, since then. So trying to update the law is very, very important.
And I think it's definitely timely. I appreciate the comments before that we're past time to really solidify this in the code. To your point, with the expiration of the temporary legislation, since we are administering an administrative process, we've been able to continue on with what had been put in place. We want to make sure it's codified in the law going forward.
All right, well, thank you very much. I think we covered many, and in fact, we covered all of our questions today. And so I want to thank you, Mr. Hubbard, and thank everyone who participated in today's public hearing for their contributions on the amendments of these three bills. If the public has any additional thoughts or would like to submit written testimony regarding the legislation, please email it to housing@dccouncil.gov, and it will be included in the hearing record, which will close on Thursday, September 29th, 2022 at 5 p.m. The committee's next meeting will be on the 29th of September at 10:30 a.m. It will be a public roundtable on the following nominations for the Housing Finance Agency Board of Directors, including Brian Scotty Irving, Heather Howard, and Stanley Jackson. This concludes the hearing for today, and with that, the time is now 12:58 p.m. on Thursday, September 22nd, 2022, and this meeting is adjourned. Thank you to everyone and to my team and to our staff.